So here's a short story about a recent court decision that I found outrageous. I think you will agree that the facts are outrageous, and I'm happy to report that the court corrected the wrong from the underlying court. This is an appeals decision. Grab your popcorn, and we're going to talk for maybe 10-15 minutes about Jack, which is not his real name, and I found it very irresponsible of certain news publications that revealed Jack's real name, because Jack is the victim, and I'll just let it speak for itself. In 1990, when Jack was 12 years old, he started working part-time at J&J Cafeteria as a dishwasher. He has an intellectual disability with an IQ of 70. After a few years of part-time work, Jack dropped out of high school and started working full-time at the restaurant. For the first 19 years of his employment, when the restaurant was owned and managed by different members of the Edwards family, Jack was always paid for his labor. That, however, changed in September of 2009 after Bobby Edwards took over the management of the restaurant. Edwards moved Jack into an apartment attached to the restaurant and forced him to work more than 100 hours per week without pay, usually 6 a.m. to 11 p.m. for 6 days a week and 6 a.m. to 2 p.m. on Sundays. Not only did Jack work long hours without pay, he was never given a day off. Edwards effected this forced labor by taking advantage of Jack's intellectual disability and keeping Jack isolated from his family, threatening to have him arrested, and verbally abusing him. His control over Jack also involved physical abuse. Once, when Jack failed to deliver fried chicken to the buffet as quickly as Edwards had demanded, Edwards dipped metal tongs into hot grease and pressed them to Jack's neck, resulting in a burn that fellow employees had to immediately treat. Other times, when Jack made supposed mistakes, Edwards whipped him with his belt, beat him with kitchen pans, and punched him with his fists. This treatment left Jack physically and psychologically scarred. Jack later said, "I felt like I was in prison. Most of the time I felt unsafe, like Bobby could kill me if he wanted. I wanted to get out of that place, so bad, but I couldn't think about how I could without being hurt." Edwards' reign of terror over Jack ended in October of 2014, when a relative of a restaurant employee alerted the authorities to Edwards' abuse, and the South Carolina Department of Social Services removed Jack from J&J Cafeteria. First, round of applause for the relative of the restaurant employee. You are a hero for turning Edwards in and getting Jack rescued. That's beautiful that you did that. You didn't have to do that, but you did, and you're a hero in my eyes for that. Edwards thereafter pled guilty to 1 count of forced labor in violation of the TVPA, the Trafficking Victims Protection Act, and the district court sentenced him to 120 months or 10 years imprisonment. In addition, the district court ordered Edwards to pay restitution to Jack in the amount of $273,000. The government had requested an additional or doubling of $273,000 in the form of liquidated damages as provided by the Fair Labor Standards Act, but the district court rejected that request, reasoning that the Fair Labor Standards Act liquidated damages clause are for statutory punitive damages that are not available as restitution under the Trafficking Victims Protection Act. From the district court's judgment dated November 6, 2019, the government filed this appeal, contending that the district court erred in refusing to include liquidated damages in its order of restitution. And you, government prosecutors, are also my heroes for fighting for Jack, even though you probably didn't have to file the appeal. We have prosecutorial discretion in the US, so it's not compulsory to appeal. The TVPA, which was passed to implement the 13th Amendment against slavery or involuntary servitude, provides that a person who obtains forced labor shall be punished by a fine or imprisonment up to 20 years or both. Specifically, it punishes any person who knowingly provides or obtains the labor or services of a person by, among other means, force, threats of force, physical restraint, or threats of physical restraint to that person or another person, or serious harm or threats of serious harm to that person or another person. In addition, the Act provides that the court shall order restitution, directing the defendant to pay the victim the full amount of the victim's losses. And it defines the full amount of the victim's losses to have the same meaning as provided in the mandatory restitution section of another law, and shall in addition include the greater of the gross income or value of the victim's services or labor, or the value of the victim's labor as guaranteed under the minimum wage and overtime guarantees of the Fair Labor Standards Act. I'm really not sure how the court could have ruled any other way. I mean, it's right there in black and white. It says the Fair Labor Standards Act applies when you've got this TVPA law. The Section 2259 in turn defines the full amount of the victim's losses to include any costs incurred or that are reasonably projected to be incurred in the future by the victim as a proximate. Proximate result means the legal causal chain, so as a legally recognized cause of the person's suffering or victimization. Result of the offenses involving the victim, including medical expenses, attorney's fees, and lost income. The Fair Labor Standards Act guarantees employees a federal minimum wage of $7.25 per hour and overtime compensation at 1.5 times the employee's regular rate of pay for anything over 40 hours per week. The Fair Labor Standards Act also provides that an employer who fails to pay the minimum wages and overtime compensation is liable for liquidated damages in an amount equal to the unpaid minimum wages and overtime compensation, effectively a doubling of that amount. Liquidated damages is a legal concept that it would be hard to determine what the proper amount of damages is, so we're just going to choose a number that we feel is a good representation. In copyright, we have statutory damages of $750 minimum, which is very similar to a liquidated damages clause. In contract, you can put a liquidated damages clause into your contract, and there are some limits, but if the parties agree that if this agreement is breached, the liquidated damages are $10,000, that's going to override any actual damage measurement. So if we have a contract that you're not going to crash your car into my fence, and it has a $10,000 liquidated damages clause, rather than going through the hearing of how much the fence was worth, you're just going to pay $10,000 if you crash your car into my fence. In short, the TVPA mandates that a court order a person found guilty of obtaining forced labor to compensate the victim for the full amount of the victim's losses, including, as one option of measurement, the value of the victim's labor as guaranteed under the minimum wage and overtime guarantees of the FLSA. The question that we must now decide is whether that value of labor includes an award of liquidated damages for an employer's failure to pay minimum wages and overtime compensation on time. In contending that the district court erred, the government argues simply that the TVPA expressly incorporates all of the FLSA's minimum wage and overtime guarantees, including the liquidated damage provision. I mean, it's right there in black and white. How could you decide otherwise, Judge? Our analysis begins with the text. The TVPA does mandate that the court order restitution in the full amount of the victim's losses resulting from the forced labor, and the full amount includes the value of the victim's labor as guaranteed under the minimum wage and overtime guarantees of the Fair Labor Standards Act. This section references the entire FLSA, not just some section which addresses minimum wage and overtime compensation. To be sure, those sections do fix the amount for compensating employees, but when the employer fails to comply with those provisions, the FLSA adds to that compensation liquidated damages of an amount equal to the unpaid wages or overtime compensation. The FLSA's liquidated damages requirement makes perfect sense when considering that the goal is to provide full compensation to employees. Minimum wages and overtime compensation must be paid on a current basis as work is done, such that an employee receives the prescribed compensation without delay. So if you're not paid as an employee on time, you're pretty much due double, as long as you can make the claim and succeed at court. But when an employer fails to pay those amounts, the employee suffers losses, which includes the loss of the use of that money during the period of delay. So fully compensating the employee requires accounting for losses from the delay. So what would those losses be? How would you calculate that? Would that be the interest, which is currently like nil during this COVID-19 pandemic? Would it be a high interest rate? Would you just decide on it? No, there's already a damages clause built into the law, so you don't have to calculate those things and hold a hearing and have testimony and pay attorneys, etc., etc. Those additional losses could in part be compensated by interest. Foregone interest is one aspect of a victim's actual loss, but the FLSA provides more fully for losses from delay by providing liquidated damages, which can include not only interest but also other losses caused by the delay. As well understood, liquidated damages are, by definition, compensation for a reasonable estimation of actual damages. And in the case of the FLSA, they compensate for the employer's retention of a workman's pay, which may result in damages too obscure and difficult to prove for estimate other than by liquidated damages. As the Supreme Court explained more particularly, the FLSA's liquidated damages provision constitutes a congressional recognition that failure to pay the statutory minimum on time may be so detrimental to maintenance of the minimum standard of living necessary for health efficiency and general well-being of workers that double payment must be made in the event of delay in order to ensure restoration of the worker to that minimum standard of well-being. So on that reading, it sounds like only the minimum gets doubled, but you'd have to talk to your labor attorney to find out what their interpretation of that clause is and what their research on that clause is. This is not legal advice. This is not individualized legal advice. Don't quote me when you're going to make a claim under the FLSA against your employer. Talk to your labor attorney first. For this reason, awarding liquidated damages for violations of the FLSA's minimum wage and overtime provisions is the norm. They are awarded to provide employees full compensation for violations of the FLSA and are therefore part of the value of the victim's labor as guaranteed. Therefore, they must be included when calculating restitution under the TVPA according to the value of the victim's labor. Indeed, it would be inconsistent with the TVPA's requirement of providing restitution not to compensate a victim for losses incurred as a result of the delay in paying required wages and overtime. And failing to compensate for delay would be particularly egregious in this case, where Jack was not paid for many years. In reaching the opposite conclusion, the district court reasoned that the FLSA liquidated damages provisions are punitive and apply only in civil cases. Edwards joined in that argument, adding that reimbursing Jack for the withheld minimum wages and overtime compensation addresses all of Jack's actual losses, but no more. But this argument fails to understand that liquidated damages are generally an amount determined to be a reasonable estimation of actual damages that might be difficult to estimate or calculate, and that is their role in the FLSA. The Supreme Court has long so held, stating that the liquidated damages for failure to pay the minimum wages are compensation, not a penalty or punishment by the government. It's literally in the law. I'm really not sure how the lower court judge could get this wrong. It's not an interpretation. It's literally black and white in section 206 and 207, as the judge outlines here. It's also in case law, Overnight Motor Transportation Corp., a Supreme Court case, and Roy v. County of Lexington, a Fourth Circuit case. At bottom, we conclude that the value of the victim's labor as guaranteed under the minimum wage and overtime guarantees of the FLSA includes liquidated damages provided by the FLSA. This fulfills the defendant's obligation to compensate the victim for the full amount, which includes the full value of his labor. Accordingly, we vacate the district court's award of restitution and remand for its recalculation consistent with this opinion, vacated in part and remanded. So if we take that calculation, what did I say? It was $273,000. That makes the full restitution $546,000. So although Jack suffered a lot under this Bobby Paul Edwards character, and I'm glad that Edwards is going away for at least, I think it's 85% of his sentence for good behavior. I'm not sure how it all works with prison sentences under federal law, but he should be going away for the majority of the 120 months imprisonment, and he'll have to pay $546,000 in restitution. Now, I don't know how he pays that. Does he have $546,000 in savings? Are they going to seize that property? Or does he not have that? Why was he not paying him in the first place? Was that money being spent on something? And if it's been spent, what property does Edwards have? So it's not the end of the road for Jack. Jack doesn't just get a check for $546,000 from Edwards unless Edwards actually has that to give. The judgment will probably have to be executed. It could be. How about this? The judgment might need to be executed at the county level and then visited upon Edwards and his property, and then there will be maybe payments made out of whatever Edwards' income is in prison, which is really minimal, if anything at all. If you labor in prison and get paid, it's usually like a couple dollars per day. So I don't think that's providing much compensation for Jack. And then we would need to know whether Edwards himself has any property that Jack could get at. Perhaps the restaurant is still running and now Jack will have a lien, basically partial ownership against the restaurant that he's worked at for 40 years now. I'm not sure if Jack is still working there. I'm assuming he's not, but maybe he'll have part ownership of the restaurant and have profits or distributions or something from the restaurant's profits. There's also the possibility that the restaurant shut down after this. If I find any information out about that, I'll try to make a little voiceover in here. So it looks like J&J Cafeteria in Conway, South Carolina is still open. I'm just going off of this New York Times article that says it was J&J Cafeteria, a buffet restaurant in Conway, South Carolina. Looks like it's still open now from 6 a.m. to 2 p.m. And real interesting, there's a bunch of question and answers. Why are people still supporting this restaurant? They kept a disabled black man enslaved for 23 years. My thoughts exactly. It disgusts me that anyone would continue to patronize this restaurant. I don't know, where is Jack going to be getting his restitution from? Maybe the restaurant needs to stay open and people should support it so that Jack can get his money back. Lots of people do not really like the restaurant's role in Edwards' abuse. So yeah, that's the status of that, it looks like. But I'm glad that there was at least justice for Jack. Not that Jack didn't suffer for what seems to be the better part of 2 decades under Edwards' fist. But at least there was justice for Jack. Let me know what you think in the comments below. And that's our show. Thanks for joining me. I'm Leonard French, your favorite copyright attorney, and this is Lawful Masses, your favorite legal news and education program here on YouTube, also on Floatplane and on twitch.tv/lawfulmasses, live on Sunday mornings at 10 a.m. Eastern Time. This is a community-supported channel, which means I need your money. It takes time and effort to make these videos, and in order to make room in my life, I need to also have support. So I really appreciate your support on patreon.com/ljfrench or sponsus.com/law. You can support the channel through YouTube memberships, or you can support the channel through Floatplane subscriptions. Thank you very much in the month of May to the following $50 plus supporters: Joe Tyson, John Steele, Gavin Barnard, Eevi, Spirit Bear, Benjamin Hitov, Ugly Grill, Rudolph Bescherer Jr., Brandyn, Abel, Torpedan, RDHDragon, Earthbound Star, and ShadowTycho. And thank you to the $5 plus supporters who are scrolling on the screen in front of me. You're all on the LED tablet behind me. I love you all. Thank you for joining me. I'm Leonard French. I'll see you in the videos that drop and the comments below.